June 21, 2024. The Supreme Court issued an 8-1 decision that gun owners are calling the most important Second Amendment ruling since Bruen. But here's what nobody is telling you. This wasn't a victory for gun rights. It was the Supreme Court clarifying how Bruen actually works, and what it means is that some gun restrictions can survive the historical test. The case is United States v. Rahimi, and it's about whether the government can disarm people under domestic violence restraining orders. 8 justices, including conservative justices Roberts, Kavanaugh, and Barrett, said yes. Only Justice Clarence Thomas dissented. If you've been following gun cases after Bruen, you know lower courts have been striking down gun law after gun law because they couldn't find exact historical matches. Age restrictions? Gone. Public carry bans? Gone. Magazine limits? Gone. But Rahimi just changed the game. The Supreme Court said, stop looking for perfect historical matches. Look for analogous traditions. Let me show you exactly what this 8-1 ruling means for your gun rights going forward. To understand this ruling, you need to know what happened to Zaki Rahimi, December 2019. Arlington, Texas. Rahimi gets into a violent altercation with his girlfriend. According to court records, he knocks her to the ground, drags her back to his car, and fires a gun into the air to intimidate her. His girlfriend gets a domestic violence restraining order. Under federal law 18 U.S.C. 922G8. Anyone subject to a DVRO that includes a finding of credible threat to physical safety cannot possess firearms. But over the next few months, Rahimi is involved in 5 separate shooting incidents. In Texas, December 2020, shoots. At someone's car, January 2021, shoots. At a constable's vehicle, February 2021, shoots in the air outside a burger restaurant after a credit card. Declined February 2021, shoots at another motorist. Multiple other violent incidents. Police search his home. They find a pistol and a rifle. Rahimi is charged with violating 18 U.S.C. Section 922G8, possessing firearms. While under a domestic violence restraining order, Rahimi's lawyers argue the Second Amendment protects his right to bear arms. This federal law is unconstitutional under Bruen because there's nitrogen monoxide, historical tradition of disarming people subject to restraining orders. The district court convicts him. He appeals to the Fifth Circuit Court of Appeals, and here's where it gets crazy. The Fifth Circuit reverses his conviction. They rule that 18 U.S.C. 922G8 is unconstitutional because, according to their reading of Bruen, there's no exact historical match for this type of gun restriction. The Fifth Circuit wrote, we conclude that Section 922G8 fails Bruen's historical test. Gun rights advocates celebrated. But domestic violence groups were terrified. This meant anyone under a restraining order could legally possess guns even if they'd already committed violence. The federal government appealed to the Supreme Court, and on November 7, 2023, the Supreme Court agreed to hear the case. Before we get to the Rahimi decision, you need to understand what Bruen said gun cases should look like. In New York State Rifle and Pistol Association v. Bruen, 2022. Justice Clarence Thomas wrote for a 6-3 majority and established a new test for gun restrictions. Step 1. Does the Second Amendment's plain text cover the conduct? If the answer is yes, the person wants to carry a gun in public for self-defense. Move to Step 2. Step 2. Is the gun restriction consistent with America's historical tradition of firearm regulation? The government must show that similar restrictions existed in 1791 when the Second Amendment was ratified, or 1868 when the 14th Amendment was ratified. If no historical analog exists, the law is unconstitutional. This replaced the old interest balancing test where courts would weigh public safety benefits against Second Amendment burdens. Bruen said, nitrogen monoxide more. History is the only test, but here's where lower courts got confused. How similar must the historical analog be? The Fifth Circuit in Rahimi said, it must be very similar, almost identical. If you can't find a law from 1791 disarming people under restraining orders, the modern law fails. But the Supreme Court was about to say, that's way too strict. June 21, 2024. Chief Justice John Roberts announces the decision from the bench. 8-1. The Supreme Court reverses the Fifth Circuit and upholds the federal law disarming domestic abusers. But more importantly, the court clarifies how Bruen works. Chief Justice Roberts writes for the majority, when a challenged regulation addresses a general societal problem that has persisted since the 18th century, the lack of a distinctly similar historical regulation addressing that problem is relevant evidence only in the sense that it suggests that the legislature has addressed the problem more recently than a long-standing historical tradition would suggest. Translation: you don't need an exact match. You need an analogous tradition. The court identifies a historical analog. Founding-era laws allowed courts to require individuals to post surety bonds, money guaranteeing good behavior if they posed a threat to others. If someone refused or couldn't pay, they could be jailed or disarmed. These surety and going armed laws from the 1700s, 1800s show a tradition of disarming people who threaten violence, Roberts writes. Since the founding, our nation's firearm laws have included provisions preventing individuals who threaten physical harm to others from misusing firearms. The court concludes, Section 922G8 fits within this tradition. It's constitutional. What about Justice Thomas? Justice Clarence Thomas, the author of Bruen, is the only dissent. He writes, the court and government have not identified a single historical law revoking a citizen's Second Amendment right based on possible interpersonal violence. Thomas argues the majority is watering down Bruen's strict historical test. He believes if there's no clear historical match, the law must fall, but he's alone. Even conservative justices Alito, Gorsuch, Kavanaugh, and Barrett joined the majority. So what does Rahimi's 8-1 decision mean for gun owners and gun rights going forward? I'm MPACT number 1. Lower courts must stop requiring exact matches. Before Rahimi, lower courts were striking down gun laws because they couldn't find perfect historical matches. After Rahimi, courts will look for analogous traditions. Example: the Third Circuit struck down a ban on 18 to 20-year-olds carrying handguns because there was no exact 1791 law banning it. After Rahimi, courts might uphold it by pointing to historical traditions of age-based restrictions. Impact. Number 2. Presumptively risky people can be disarmed. Justice Kavanaugh's concurrence introduces the concept of presumptively risky people. This includes people under domestic violence restraining orders, convicted felons, in most cases, people with severe mental illness, habitual drug users. Maybe this is pending in U.S. v. Rahimi. If you fall into these categories, Rahimi suggests the government can constitutionally disarm you. Impact. Number 3. Age restrictions may survive. Before Rahimi, multiple courts struck down age-based carry restrictions for 18 to 20-year-olds. After Rahimi, those laws might survive by pointing to historical traditions of age-based regulations, though this is still being litigated. Impact. Number 4. Sensitive places. Laws get guidance. States like New York tried to designate everywhere as sensitive places where guns are banned. Courts push back. Rahimi suggests that some sensitive place restrictions, those with historical analogs like courthouses and legislative assemblies, will survive. Impact. Number 5. Magazine limits and assault weapons bans still vulnerable here. That's what Rahimi does not save. Modern bans on commonly owned firearms and standard capacity magazines. AR-15s are the most popular rifle in America, 24 million in circulation. There's no historical tradition of banning commonly owned arms. Rahimi doesn't change that. Magazine capacity limits, also no historical analog. Those remain vulnerable under Bruen. Justice Clarence Thomas wrote a powerful 28-page dissent, and gun rights advocates are worried that his position, the original Bruen test, is being abandoned by the rest of the court. Thomas writes, not a single historical regulation justifies the statute at issue. He argues that Surety laws and going armed laws are not analogous to modern domestic violence restraining orders because surety laws required proof of a CTUL threat before disarming someone. Modern restraining orders can be issued based on lesser standards. Surety laws apply to everyone, not just specific individuals. Modern law targets specific people based on court orders. Surety laws were temporary. Modern restraining orders can last years. Thomas concludes, the court and government have not identified a single historical law revoking a citizen's Second Amendment right based on possible interpersonal violence. He warns that the majority is creating a watered-down version of Bruen that will allow more gun restrictions to survive. Gun rights groups agree with Thomas. Gun owners of America called the decision devastating. The Firearms Policy Coalition said it weakens Bruen's protections. But here's the reality. Thomas is alone. 8 justices, including conservatives, appointed by Republican presidents, disagree with him. Rahimi is just one Supreme Court gun case. Here are the others pending or recently decided. United States v. Rahimi, granted October 2025. Question: can regular marijuana users possess firearms? 38 states have legal medical marijuana. But federal law, 18 U.S.C. Section 922 G.3, says drug users can't have guns. The Fifth Circuit struck down this law as applied to regular users. The government appealed. Supreme Court oral arguments expected January-March 2026. Decision June 2026. Rahimi's logic could save this law by classifying drug users as presumptively risky people. Wolford v. Lopez, granted October 2025. Question: can states require express permission from property owners before carrying guns into businesses? Hawaii's law bans carry on 96.4% of land unless you get permission first. The Supreme Court will decide if this violates the Second Amendment. Oral arguments January 20, 2026. Decision June 2026. Rahimi doesn't directly affect this case, but the analogous tradition test will be applied. Illinois assault weapons ban, 7th Circuit. Judge McGlynn struck down Illinois AR-15 ban in 168-page ruling. Case pending at 7th Circuit. Could reach Supreme Court 2026 to 2027. Rahimi does not save this ban because AR-15s are commonly owned firearms. Machine gun cases, multiple circuits. Several defendants are challenging 18 U.S.C. Section 922, the 1986 ban on new machine guns for civilians. Circuits are split. Some uphold the ban. Others are skeptical. Supreme Court may take this issue soon. Rahimi's presumptively risky logic probably doesn't apply to machine guns because they're arms under the Second Amendment, not people. So what should you, as a gun owner, in light of Rahimi? Action number 1. Understand Bruen is still strong. Rahimi did not overturn Bruen. It clarified it. Gun restrictions still need historical analogs. The government still has the burden of proof. What changed? Courts don't need perfect matches. Analogous traditions work. Action number 2. Know which restrictions arrive after Rahimi. These restrictions are more likely to survive. Domestic violence restraining order disarmament. If order includes credible threat finding, felon in possession, laws for violent felons, severe mental illness, disarmament, possibly habitual drug users. Pending Rahimi case, these restrictions remain. Vulnerable, assault, weapons bans, no historical analog for banning. Commonly owned arms, magazine capacity limits, no historical analog. Excessive, sensitive places. Restrictions, age-based restrictions, still being litigated. Action number 3. Watch the Rahimi and Wolford C. Zhejiang. 2026 will be massive for gun rights. 2 major decisions expected. Rahimi, marijuana users and guns. Wolford, private property carry restrictions. Both will further define how Bruen works post-Rahimi. Action number 4. Support gun rights. LITAGAO and organizations like GOA, FPC, SAF, and NRA are fighting these battles in court. They need funding. Even $10 a month helps. Action number 5. If you're subject to DVRO, consult ATTRNY if you're facing a domestic violence restraining order. Do not possess firearms until you consult with an attorney. Rahimi makes clear that the government can constitutionally disarm you if the order includes a credible threat finding. Rahimi reveals a fundamental tension in Second Amendment law. Individual rights versus public safety. Justice Kavanaugh's concurrence addresses this directly. He writes that the Second Amendment protects the rights of law-abiding, responsible citizens, but people who threaten violence are not law-abiding. This creates a category of presumptively risky people who can be disarmed. Violent criminals, domestic abusers who threaten, harm severely mentally ill individuals, possibly. Drug users critics argue this is a slippery slope. Who decides who's presumptively risky? Could the government expand this category to disarm more people? Gun rights advocates say, the Second Amendment protects everyone, not just people the government deems safe. But 8 Supreme Court justices disagree. They believe the Founding Fathers understood that dangerous people could be disarmed. The fight continues. But Rahimi clarifies that Bruen's historical test is not absolute. There are exceptions for genuinely dangerous individuals. Here's the bottom line. June 21, 2024's 8-1. Rahimi decision did not overturn Bruen. It clarified. Lower courts were being too strict. They were striking down gun laws because they couldn't find exact historical matches. The Supreme Court said, look for analogous traditions. This means some gun restrictions, particularly those disarming genuinely dangerous people, will survive constitutional challenges. But it does not mean assault weapons bans. Magazine limits or excessive sensitive place restrictions are safe. Those still lack historical analogs and remain vulnerable. The fight for the Second Amendment continues. And the next major battles will be decided in June 2026 when the Supreme Court rules on marijuana users, Hamani, and private property carry restrictions. Wolford, subscribe and turn on notifications so you don't miss those critical decisions. Drop a comment. Do you think Rahimi weakened Bruen? Or did it just clarify how the historical test should work? Share this with every gun owner you know. Most people don't understand what this 8-1 decision actually means. The Supreme Court has spoken. And while Justice Thomas stood alone, 8 justices agreed. The Second Amendment protects law-abiding citizens. But dangerous people can be disarmed. Stay informed. Stay legal. And stay ready for June 2026.